Hello, everyone. Thanks for joining us for today's episode of Subro Sessions titled Speak Now or Forever Sign That Release. My name is Sara, and I'm a partner in the White and Williams Subrogation Department.
My name is Lian Skaf, and I'm a partner in the subrogation department also. Today, we're going to be doing part two of our topic Speak Now or Forever Sign That Release. If you haven't listened to part one, it's up wherever you get podcasts. And in that episode, we talked more generally about releases, some topics to be aware of, some kind of general tips. And in today's episode, we're going to extrapolate a little bit on that and talk about some applicable case law and some specific provisions you might want to consider or look out for. So, first, I'm going to hand it over to Gus, who's going to talk a little bit about language and releases and how they're applied.
Yeah, so since we're talking releases here, let's start with the specific release language. The few sentences or paragraph that actually identifies what is being released. Now, as we've pointed out already, and Lian mentioned this in the last podcast episode, in our careers, we haven't really seen a release become an issue after it was executed or coming back to bite us in any way. So it is a rare occurrence from our perspective. But that being said, in the rare event that a release does become an issue, it could be very problematic. So you want to be careful with the specific release language and make sure you know what every word in the release is intended to mean. And to break this down so that everyone understands, we're going to discuss a 2024 PA Superior Court case called Werner v. 1281 King Associates LLC. Now, this case is not a subrogation case, but the lessons learned from the interpretation of the release are very much relevant to any case, civil case involving a settlement release. So, just some background on this case. In February 2019, the plaintiff, Mr. Werner, was injured while on the defendant's property, which was a bakery. The plaintiff suffered a hip fracture requiring surgery. In February 2020, he sued the defendants for pain and suffering, loss of wages, and loss of consortium. Now, there's a little backstory here. In 2014, Mr. Werner, as principal of Werner Bread Man LLC, entered into a distributor agreement with the defendants, which designated Mr. Werner as the exclusive distributor for the defendants. In July 2019, after the slip and fall incident, Mr. Werner entered into a termination, release, consent, and arbitration agreement in which the defendants agreed to allow Mr. Werner to assign his distribution rights to another party in exchange for a termination of the distributor agreement. The termination agreement contained the following release language. In consideration for the representations, warranties, covenants, and agreements of Martins, the defendants, set forth in this agreement, the distributor parties, which included the owner, Mr. Werner, hereby release, remise, and forever discharge the Martins parties to the extent permitted by applicable law from any and all actions, cause of actions, claims, counterclaims, cross claims, demands, rights, suits, debts, contracts, agreements, demands for contribution, demands for indemnity, damages, costs, loss of services, expenses, commissions, and compensation of any nature whatsoever, whether known or unknown, fixed or contingent, and whether at law or in equity, that any distributor party has or could have asserted against the Martins parties at any time on or before this date of this agreement in any way arising out of, relating to, or having any connection with the distributor agreement.
Hopefully, everyone just memorized that. Okay, go ahead.
Well, the most important part of that is the very end of that release where it said, any time on or before the date of this agreement in any way arising out of or relating to the distributor agreement.
Lawyers love this kind of language when it's anything, everything from the beginning of time to
the
end of time.
Yes. The defendants filed a preliminary objection seeking dismissal citing the release language in the termination agreement, and the lower court granted dismissal, dismissing the Warner's personal injury case against the defendants for the slip and fall injury. The Warners argued that the phrase arising out of in the release was ambiguous because it didn't clarify if it meant a generally related to the cause or a substantial factor to the cause of the loss. While Mr. Warner was arguably on site because he was the distributor, the slip and fall was related to alleged defects in the ramp and not necessarily directly related to the distributor agreement. Well, the court disagreed, finding that arising out of meant any obvious causal connection to the agreement. And since Mr. Werner was on the property as part of being a distributor, it did arise out of the distributor agreement. I don't know what your opinion is on that, Leon. Could be a stretch, but goes to show how careful you have to be when drafting the language and how a release can relate to matters that one would not originally think or intuitively think is related to the release agreement.
My opinion on it is that it kind of shows you that when people say you never know how a jury is going to find, sometimes you never know how a judge is going to find either, because I never would have guessed that they would have agreed with that interpretation in this scenario.
Right. So Pennsylvania court indicated that the effect of a release is determined by the ordinary meaning of its language. When construing the effect and scope of a release, the court must try to give effect to the intentions of the parties. Yet the primary source of the court's understanding of the party's intent must be the document itself. That's why we've said in the first episode, and we're saying now, it is very important to examine and understand all four corners of that release before agreeing to sign it.
And that's why you say from the beginning of time to the end of earth, cover every basis.
Okay, so now that we've talked about the actual release language, we're going to go into the indemnification and hold harmless part of the release. Preferably, there won't be one, but lately we've been seeing that the other side has been increasingly requesting that there be some kind of indemnification and hold harmless provision. Arguably, these provisions take the release farther than anyone would initially intend on a release reaching, because not only now do you release any claims, but now you're agreeing to pay for the expenses related to anyone else possibly bringing a claim.
Yeah, and when it comes to indemnification, I think it's obviously a very important provision where defense counsel always wants it. We never want it. So I think a lot of the success in our job is finding the middle path, the path of least resistance here. You know, you don't want to concede and give them what they want, but you don't want to litigate a claim that you don't need to over this provision. So, I think with this next part where we're going to talk about different provisions, I like to kind of refer to as making them think you're giving them what they want when you're really giving them nothing at all. So the big one being indemnification. First, I think Gus is going to give us an example of a provision dealing with indemnification that is just too overly broad.
Right. So this is an example of the type of indemnification provision that we receive initially when the defense proposes a release. And here's an example. The undersigned further agrees to indemnify and save harmless the releasees of and from all damage and expense, including attorney's fees by reason of the above claim, should any further claim, demand, or suit therefore be made by or on behalf of the undersigned against releasees. The undersigned further agrees to indemnify and save harmless the releasees of and from all expense, including attorney's fees, should any claim, demand, or suit therefore be made by any person, firm, company, organization, state, or federal agency or hospital as a result of, in connection with, the claims hereby released.
Yeah, so a random tenant comes, you're paying. A neighbor comes, you're paying. I mean, everyone in the world, we're indemnifying under that provision.
Yes, very dangerous, leaves your client open to a lot of potential liability and exposure.
Right. So now our response, obviously, the first response I should say to that would be no way, no indemnification. And hopefully they say, okay, fine, we move on. That happens more often than you think. They kind of just put it out there, and once we say strike it, they'll agree. But let's talk about the middle path. They say no, we have to come to some sort of agreement. That's where you make them think you're giving them something, but you're really giving them nothing. So I'm not going to read the whole intro part. I'll just read the end part of a provision where it makes it seem like we're giving them something, but we're not. So it starts off typically with the releasing party agrees to defend, indemnify, save, hold harmless, etc., and then ends at related to the rights assigned to and subrogated to the releasing party. That little phrase right there just says, I'm giving you everything, but only if it pertains to my claim that I'm releasing right here, which, in my estimation, if you write that correctly, is essentially giving them nothing. We're saying, yes, we'll indemnify the claim that we're already releasing. Another way to do that is to say up to the amount paid. Now, that may leave you a little bit more exposed because someone could argue that a third party claim can be recoverable if it's within what you paid. But if you structure that language correctly, also, you really can limit just to what you've paid and what your specific client has paid. Another way to put that is to say releaser agrees to defend, indemnify, etc., from and against any such liens against releasees for releasers' claims and against releasees. So in that context, all we're really indemnifying is if someone comes or already has a lien against our client's claim, which I've never even heard of. So again, we're agreeing, quote unquote, to put indemnification language in there, but we're really not giving up anything.
Or if someone makes a claim against the settlement proceeds, that's a little more tailored as well. And the tailored version that Lian just read pretty much says that we will indemnify you for any claims that we may bring. And that's essentially just going hand in hand with the release. We already said we're not going to sue you, so why not say we'll indemnify you if we sue you?
Yeah, like anything else, the devil's in the details. I mean, you got to craft it with the right words so that you're giving up nothing, but there are multiple ways of doing it. Two other quick provisions that come up often. I want to kind of give an example of how to do that same trick of giving up nothing. Confidentiality. Confidentiality, as we mentioned in the last episode, is something that defense often wants, and we often don't care that much about. If you want to keep it secret, that's fine. But our clients are insurance companies, and they can't, papers pass and emails pass through files. So what I normally do is say, yes, we'll agree all this stuff, and at the end I say, except for in the normal course of insurance business. It's pretty general. It allows for a lot of, typical files and emails and passing where we're not violating the confidentiality provision. Almost probably count on one hand the time I got pushed back with the inclusion of that phrase. Second provisions, when you want to preserve the claims of your insured, when you're doing your subrogation release, a lot of times defense counsel will say, no way, that's off the table. But when you do it, there are ways to craft it where you can say, we're releasing our claims, actions, suits, etc., except for, and I would be very specific of naming the name insured and then saying, and any other named insureds that were not reimbursed by XYZ insurance company. Make it very clear that we are not releasing this claim by this insured, by any additional insureds, only to the extent of what is being paid. Make it specific.
Agreed. That's very important if you're not representing the insured and they may have uninsured losses. And sometimes, I think Leon's going to discuss later, there could be a reverse situation where the insured engages in a release and doesn't forget to carve out the potential subrogation claim. I'm going to briefly touch on unsigned releases and whether or not they can be enforceable. And I'm going to briefly discuss a federal district court case from the Middle District of Florida, a 2024 case that I think is very indicative of the factors that could come into play when determining whether an unsigned release is enforceable. This case is Cohen versus Carmel Management Group LLC. In this case, plaintiff was disabled and sued the owner of a property that he frequented, alleging violations of the Americans with Disability Act. The initial case was dismissed on a stipulation that the parties reached a settlement agreement where the defendant agreed to make the requested accommodations within 8 months of the settlement. According to the plaintiff, the parties to the settlement release never actually signed the release, though there were email exchanges with the plaintiff and the defendant's attorneys regarding the agreement to the terms of the release, and there was a settlement amount paid to the plaintiff based on these claims. When the plaintiff found out that the accommodations were not made in the agreed upon time frame, the plaintiff filed another lawsuit in the federal court seeking damages for breach of contract. The court held that it could not enforce an unsigned agreement unless the party seeking to compel enforcement demonstrates, one, the opposing party or attorney of the opposing party had clear and unequivocal authority to enter into the settlement agreement, and two, that the opposing party assented to all the essential terms of the agreement. The court found that mere payment of a sum of money outlined in the unsigned settlement agreement does not in itself render the entire document enforceable. Since the plaintiff failed to prove that the defendant's attorney had clear and unequivocal authority to enter into the agreement, the court found the unsigned release unenforceable and dismissed the breach of contract claim and the case entirely. So this is a learning lesson that you want to make sure, if you want the release to be enforceable, and sometimes the subrogating carrier is hit with cross claims, and it could be a mutual release where we want all the claims involved in the case to be fully released. And in those instances, we truly do want a fully executed and enforceable release. So I think to not run into situations like this, it is highly recommended to make sure that before you close your file, you have a fully executed settlement release in the file.
Yeah, and as Gus mentioned, lastly, we're going to flip the issue a little bit, which is essentially, what do you do when your insured has signed a release, but you still have an outstanding subrogation claim? What are the effects of that? So years ago, I had a case in New York where, I had gotten the claim a little bit after the loss, 6 months to a year. And as we progressed by pursuing our subrogation claim against the liable party, we found out that the insured had signed a release. Now, luckily, before I got the claim, my client had put the carrier for the liable party on notice. And when we got it, we sent a follow-up notice letter, and that was all done before the insured signed their own release. Thus, we were able to preserve our subrogation claim, because essentially what New York says was that the liable party's carrier cannot sign away subrogation rights by entering into an agreement with the insured when they know those subrogation rights are out there. So really the crux there is they've been put on notice and they have knowledge of the subrogation claim. And again, that's a New York case, but from what I found in a lot of other jurisdictions, it kind of turns on that same key issue there, and that's notice of the outstanding subrogation claim. Now, there was a recent case in Supreme Court of New York in Bronx County, State Farm versus Moving and Storage, Inc. So in this case, the insured signed the release, and State Farm later came out and said that, we still have our subrogation claim, and they wouldn't pay it because they said, no, you've been released. So it came down to notice. Were they properly on notice? In this case, apparently the carrier did not send a notice letter to the liable party or their carrier, but argued that since there was a joint site inspection where their investigator signed a sheet and said they were representing State Farm, that constituted notice to the liable party's carrier. The court said no, and the claim was precluded, essentially saying that, it needs to be clear, there needs to be notice, they need to have sufficient notice that there's a subrogation claim, and just mere happenstance of having an investigator at a site inspection doesn't satisfy that. I mean, if you think about it, it does make sense when they're saying just because you have an investigator there early in the days after the loss doesn't mean that the carrier has paid money, that they're pursuing it, that they have a valid subrogation claim, et cetera, et cetera. So I guess the key here is that, yes, you're insured entering into a release can preclude you from having a subrogation claim. So it's obviously state specific and jurisdictionally specific, but the lesson here, I think, is get those notice letters out. Takes a couple minutes. Make sure you're getting to the right people so that everyone knows you're out there. Once they're on notice, you're doing at least some extent protecting yourselves from a situation like this. I mean, a lot of times it's not necessarily intentional. Your insured doesn't have nefarious impetus behind this, but they're trying to get the money when they can, and they didn't realize the effect it's having on their carrier's claim. So, something to be aware of.
That is a rough decision. I'm not sure I agree with it, but I am not the court. And that was a rough deal for State Farm in that situation. But whenever in doubt, please come back to this episode and you'll be a professional or professional light on releases. And if you ever have any questions, please feel free to reach out to Lian and I. Our information is readily available on our website and on LinkedIn. And thank you for listening to this episode of Subro Sessions. You could find the past episodes of the podcast on White and Williams' homepage, whiteandwilliams.com. Hover over the Insights link and select podcast to find past episodes. Take care.
We would like to remind everyone that the contents of this podcast are intended for general informational purposes only, and you are urged to consult a lawyer concerning your own situation with respect to any specific legal question you may have. The podcast should not be construed as legal advice for a particular situation or to give a legal opinion on any specific facts or circumstances. Prior results do not guarantee a similar outcome.